Welcome everybody to Protecting Your Clients with Premarital Agreements. Christina and I are pleased to present to EP Wealth Advisors what will be a dynamic program talking about prenups. The program will last about 55 minutes and we'll open it up for questions at the end. So my name is Peter Walzer. I'm founding partner of Walzer Melcher. I've been practicing family law almost 40 years and been handling prenups for about that long. Christina?
My name is Christina Djordjevich. I am a partner at Walzer Melcher. I've been practicing law for about 12 years now. 9 of those I spent in New York City before moving to California. I focus exclusively on family law, and a large part of my practice is on drafting and negotiating premarital agreements. I find premarital agreements to be a fascinating type of contract. So we're really excited to present to you today on this topic.
And it's great to be speaking to all of you because really a premarital agreement is the ultimate financial planning event. What is going to happen in the next year? What is going to happen in the next 5 years? What is going to happen in the next 50 years? What is going to happen at death? What is going to happen at divorce? All are incorporated in a premarital agreement and discussed. So we're going to discuss all aspects of this program and prenups. So welcome everybody. Unfortunately, I don't have access to a dial-in number right now, but this will be recorded and we'll share it with you afterwards. So let's start off with the premarital agreement myths and legends. Of course, there have been lots of films about premarital agreements. One that comes to mind is Liar, Liar, where there's a great scene with Jim Carrey, who is litigating the validity of a premarital agreement. And he puts his client on the stand, and it turns out she was a minor when she signed the agreement and had a lack of capacity to enter into an agreement. Doesn't always happen like that in real life. There's also the movie Intolerable Cruelty with George Clooney and Catherine Zeta-Jones, also about prenups, and we'll talk a little bit about that prenup later. But you hear in the common discourse, premarital agreements are not really enforceable. I can easily set them aside. While it's true that some premarital agreements are set aside, I would put that at 1 to 5%. If done correctly, they are enforceable, and as we'll discuss what correctly means later on, but they are extremely powerful and change people's financial lives. Premarital agreements are inexpensive. They are not inexpensive. They are not for the average person. They are for people with wealth or people who are going to have wealth. And we charge accordingly because it's an agreement that could endure for a lifetime. It could be an agreement that is enforceable at death. It could be challenged, so you want to have the agreement drafted correctly. There are lots of nuances and subtleties. As you'll see, they're not one agreement fits all. So they're pretty tricky and they are expensive, and expensive is a relative word, but for normal folks like us, they're expensive. Premarital agreements are easy and quick to prepare. True, most agreements have a lot of common clauses, but they're not easy and quick to prepare. There's always some issue in them. And one of the tricks is you don't know where the agreement is going to be enforced. It's not the state where you get married, it's the state where you get divorced or you die. So we can only write for California, but we do try to make it so the agreements are enforceable elsewhere, but we don't guarantee that by any means. They are very tricky and they're not easy. And Christina and I have been working on a lot of agreements, and we are just going back and forth about these difficult clauses. And something always comes up that we can't really plan on or expect. Premarital agreements do not impact the couple's relationship. Wrong. An agreement is mainly an emotional deal. It's 5%, 10% legal. It's the emotions of the parties, the issues of, do you trust me, always come up. It's like, why do we need this agreement? I thought you trusted me. Common complaint. And it does set a seed for the future about dealing with this and emotionally, and it comes back and back and back. Why don't you tear up the agreement? Why do we need a pre-agreement? That kind of thing. So really the lawyers have to be sensitive and the advisors need to be sensitive to the emotional component about prenups. Premarital agreement are one size fits all. No, as you'll see later on, one size doesn't fit all. Different agreements for different couples, for different people. There are agreements that are, the parents want the prenup. For example, trust fund children. They're getting married in their 20s. There's a trust fund. It's really the parents that are the real client. They want the trust fund. They want the premarital agreement to protect their children's inheritance or gifting during the lifetime. Then there are the children that want the prenups for their senior parents that are getting married a second or a third time, and they want to protect their inheritance. The adult children are the clients. Then there's the dynamic of the very wealthy fiance marrying the person who has nothing. Not one size fits all. You got to customize it to each couple. And the sixth myth we're talking about is premarital agreements are right for every couple. They are not right for every couple. People without anything who are just getting married, there is a prenup for everybody. Perhaps you didn't know it. It's called the family code. It's called the probate code. It's all written out. Very complicated, but essentially everybody enters into a prenup. But a customized prenup that is drafted to provide for separate property, perhaps not right for most couples, I would say. Any comments on this, Chrissy?
Well, you know, on myths, let's see, 3 and 6, 3 and 5, in terms of prenups being easy and quick to prepare or being one size fits all. You know, we've had, you know, people say, well, why do I even need a lawyer? Why can't we just, you know, go to Rocket Lawyer or what's another one, LegalZoom, and just, you know, find a template from the internet. And the thought of that gives Peter and I nightmares. It should give you and your clients nightmares as well. A prenup is definitely not the document to be penny wise and pound foolish on. You need, you know, everybody needs attorneys, and it needs to be done right. So I'll speak a little bit about circumstances under which premarital agreements may not be right for everyone. So the first is if the wedding is less than 2 months from the date the attorney is hired. Our office typically will not take on an engagement where the wedding date is less than 60 days from the date the possible prenup comes in the door. 60 days sounds like a lot. It's not. Later in the presentation, we'll be going through a more detailed timeline of week by week from, you know, week 1 until the time that the prenup is signed. That doesn't even account for vacations, other impediments that come up. So, you know, if it's less than 2 months, then, you know, either there's not going to be a prenup or, you know, potentially the wedding needs to be postponed to ensure there's enough time.
What about, is a postnup the same as a prenup? People often ask that. Why do we have to be worried about the wedding date?
So a postnup is very different than a prenup. With a postnup, there are fiduciary duties that exist because when you're dealing with a postnup, the parties are married, and so they're spouses, and so there's a fiduciary duty. With a prenup, there are no fiduciary duties, more of an arm's length negotiation, but So postnups are much more complicated, and the disclosure duties are much greater, and there are presumptions as to unequal bargaining power and being set aside and things like that. So sometimes that's a great point, Peter. Sometimes people will think, well, okay, if we don't do a prenup, we'll just take care of all this in the postnup. But at that point, people are already married. The leverage and the bargaining power changes greatly, and a simple disclosure schedule listing, a few assets and some tax returns, probably not enough disclosure for a postnup. Peter, do you have
Also,
anything?
in a prenup, there's no consideration required by statute. In a postnup, consideration, we don't call it consideration, but there's got to be some give and take, or it's presumed to be invalid. So many reasons not to advise a client to wait and do a post-marital agreement later. It almost never happens, right?
I was going to say, both Peter and I, in our combined experience, the number of postnups that have actually successfully been signed are very, very few. Generally, at least in my experience, postnup discussions tend to morph into divorce, unfortunately.
It's so true.
So the second scenario where a prenup may not be right or advisable is where one prospective spouse does not have an attorney. So this is huge. Both parties, although not required by the code, which I'll talk about in a minute, our office will not take on prenups unless both parties are represented by independent counsel. The reasons for this are a few. One, you cannot have any provision dealing with spousal support in a prenup unless both parties are represented by counsel. So in other words, if there's a provision limiting or waiving spousal support and somebody's trying to enforce it against that party and that party was not represented by counsel at the time of the prenup, it's unenforceable. Second issue is that there are certain disclosures, certain advisements that need to be made to a party who does not have an attorney in connection with the premarital agreement under the code. So one of those is there needs to be a writing, memorializing the terms of the agreement, the effect of the agreement, and the rights and obligations that the party is relinquishing under the agreement. And Peter and I are always scratching our heads like, how can that possibly be adequately provided to an unrepresented party in a memo? These prenups are complicated documents. They can span 30, 40, 50 pages. How do you condense all of that into a memo that is then going to be deemed at some point in the future to have been sufficient? So both parties need an attorney. That's definitely best practices. The third situation in which a premarital agreement may not be right, and Peter touched on this a moment ago, is where the couple has no assets and little debt, because the question becomes, why is the prenup needed? Now, of course, if somebody is an heir, if there's a family business, if somebody's going to be receiving a lot of money from family, et cetera, down the road, that makes sense. Prenup's very common in that situation. But if that's not the case, if the couple just, doesn't have much and doesn't have much debt and no one's expected to inherit a lot of money, you really got to you got to probe into why this type of agreement is needed. Why don't they want the default regime under the family code with community property, spousal support, et cetera, to apply? And sometimes the motivations are sinister, and so that's something to consider. Next scenario, another red flag where there is a high earner spouse with assets, or either who has assets or is a high earner now, or who is expected to be a high earner, or expected to come into assets in the future that are going to then be separate, who does not want to provide for the other low earning or projected low earning spouse who may stay at home with the kids, etc. This is a big problem. When drafting and negotiating these agreements, we are always considering what the scenario is going to look like 5, 10, 15, 20 years down the road, no matter which party we represent. Because, so for example, if one party's earnings are defined as separate and the parties are married for 30 years and the other spouse stays at home to raise the kids, what is that spouse left with at the end of the day in the event of a divorce? Sometimes people are blinded by love and don't think that divorce can ever happen to them and just say, I'll sign anything. I don't care. I trust him or her. I trust him or her to provide for me. But that's you know, clients should be advised, don't trust. You know, we see divorce obviously a lot, you know, 50% divorce rate. You need to provide something reasonable, whether it's in the realm of spousal support, life insurance, a house, payments during the marriage, something to ensure that the lower earning spouse is taken care of.
And from an ethical point of view, we don't want to create a situation where somebody can't get out of the marriage because there's nothing for them. And we also don't want to create a marriage where somebody's desperate and their only choice is to litigate about the validity of agreements. Generally, they don't succeed because they are enforceable. I had a person come into my office and they were worth over $50 million and they were in their 60s and they were marrying somebody in their 20s. And they didn't want to provide anything at death or divorce. And basically, I, returned their money and said, go to somebody else because I didn't want to be part of that. It was too risky. They were giving the other person so much incentive to attack it. And even though it probably would have been enforceable, I didn't want to be involved in that situation.
Another scenario is where both parties want to waive spousal support entirely, where one or both parties want to waive spousal support entirely. We do not do, waivers of spousal support for a party. And basically, it's just, we'll talk about spousal support a bit later in the presentation, but spousal support provisions are always sort of subject to, okay, is this going to be enforced? Because the court is looking forward. You're looking forward to what a court will do at the time somebody's seeking to enforce this. Circumstances change. You don't know who's going to be working, who's not going to be working, who has, health considerations, who may become disabled. For a full waiver of spousal support, it's a very risky proposition. And finally, sometimes you see parties who want to enter into a premarital agreement for the purpose of avoiding or defrauding creditors. Somebody's after them or somebody's going to be after them, so they want to put all their assets in the name of their prospective spouse, or they don't want the income stream that would otherwise be community to be subject to, attachment or a lien or anything. So they say, okay, everything is going to be the other spouse's separate property. These agreements are vulnerable to being set aside. A very recent case, I think it was 2019, came down in California where just that happened. There was a judgment creditor that was coming after a prospective husband. There was a judgment. The parties entered into a prenup that said that all income received during the marriage remained the separate property of each party. So in other words, the husband waived his community property share of the wife's income. The creditor then brought suit to set aside the prenup under what used to be called the Uniform Fraudulent Transfers Act, I think is now called the Uniform Voidable Transactions Act. And the court held that, yes, in theory, the Uniform Voidable Transactions Act can apply to a prenup where there is actual or constructive fraud, which means that the agreement could be, if those, fraudulent circumstances were proven, could be set aside. So if the goal is to avoid or defraud creditors, it's very risky, unlikely to be successful, and don't do it, basically. Peter.
So what can premarital agreements do? And the answer is a lot. They're probably one of the most powerful agreements a person would sign in their entire life for marriage, because during a marriage, because they control so much. They can control all their property rights and obligations for divorce or death, as we've talked about. So they're both a divorce planning and a estate planning agreement in a lot of cases. And if you're going to do both, if there's a death aspect, you probably want to talk to the estate planner. You probably, and for divorce, you probably want each person to get a financial planner so they know what they can afford to do in a premarital agreement. So it can require somebody to make a will, trust, or other arrangement to carry out the provisions of the agreement. Often there's a transfer of wealth during the marriage. There's a transfer of an interest in real property. There's a contract to make a will or a trust. We often provide that life insurance be carried, and usually it's better if the beneficiary is the owner of the life insurance, but life insurance solves a lot of problems, especially in those situations where there may be children from a prior marriage. You can take care of the current spouse by providing for life insurance, in some cases relatively inexpensively. Another, most people call it boilerplate, is a choice of law clause in the agreement. The California law will apply to our agreements, not just as for interpretation of the agreement, but the substantive law of California will apply. And a lot of our practice is interstate and international. And while we can't guarantee that a choice of law will apply, it is also, it at least gives you some leverage and some context for the agreement. In cases where they don't apply, a court wouldn't apply it, or public policy issues, perhaps on spouse support or alimony, but at least gives the parties some protection. Often we get people from another state who want to write an agreement for our state, and we really discourage those, we turn those down, because California law is so specific and so nuanced. You really need a California lawyer to write another agreement. If the parties are moving to Texas or Massachusetts, we'll bring in another lawyer. And sometimes it will be one agreement, but sometimes we'll say do two agreements. Or if they're moving to France or another marital regime country, we might suggest they enter into marital regime in one of those countries. By the way, most countries are marital regimes where there's one attorney called a notaire who represents both parties. And if the parties have a vacation home in Italy or Germany or France or in many other countries, they may want a marital regime in addition to a prenup. So they get really complex. And since prenups are really for the wealthy, and wealthy people have homes in other states and countries, you want to make sure that's on your radar. So there's a catch-all. Prenups cover any other matter, including personal rights and obligations, not in violation of public policy or statute imposing a criminal penalty. So we really stay away from these. We'll talk a little bit more about what's the violation of public policy and so on. But for example, an agreement just for immigration purposes might be voidable. Lots of problems with them, something to definitely consider. But again, very powerful. We'll get into how powerful they are as we move along.
And one thing I'll add about life insurance, because we've talked about it a few times, because it can be such a useful tool to provide for, for a spouse. You can include provisions in the agreement that say that, okay, the spouse who is the beneficiary of the policy will also be the owner of the policy. You can mandate that in the agreement. So that's good, because then the, spouse can check in to he or she can receive all policy documents, make sure the policy's in effect, hasn't been canceled, something like that. So it's a useful tool to keep in mind.
So what can a premarital agreement do, Christy?
Okay, so what can a premarital agreement not do? Not do. So it can do a lot. But there are a few things that it can't do. So one thing is that it cannot limit child support. In California, the right of child support belongs to the child, and child support is determined by use of a guideline formula. So we get this question a lot, but even if, the child has been born or unborn, a prenup cannot adversely impact a child's right to support by, for example, including, well, child support will be calculated from this income stream, but not that income stream, or will somehow be limited or capped. Don't do it. Don't bother putting it in, because you can't do it. Second, aspect that a prenup cannot do is regulate child custody. This is also beyond the scope of this type of document. Again, regardless of whether the children are born or unborn, the courts in California consider what is in the best interests of the children in making custodial determinations. So that's also beyond the scope of a prenup. But we get this question a lot.
Yeah, we do. People want to guarantee there'll be joint custody or shared time with a child. Maybe they've gone through a prior divorce, they have a friend. They want to put that in the agreement. But both 1 and 2, child support and child custody, are pretty much throughout the United States can't be part of a premarital agreement. And as an aside, there are 28 states that are part of the Uniform Premarital Agreement Act, which is not very uniform. The rest of the states have their own laws. So the laws on prenups vary from state to state quite a bit. And California has enacted a lot of legislation in the last 20 years. So it's gone really off course from the original Premarital Agreement Act, which was enacted in 1986. And as another aside, there is no statute really significantly for postmarital agreements. Another reason we don't like postmarital agreements.
True, very true. And so the other aspects are that the prenup cannot violate public policy, and the prenup cannot violate a statute imposing a criminal penalty. So, and sort of relatedly, a prenup cannot, for example, do things like penalize people for not doing household chores, not doing the dishes, or otherwise legislate that kind of personal conduct within a relationship. You may be surprised to hear how often we get asked these kind of questions. Some examples are, some people want, for example, to include a provision saying if a spouse is unfaithful, I want a payment, I want more of the property. That's not enforceable. That's not something that can be, enforced in a premarital agreement. Similarly, a spouse, there have been situations where somebody will say, okay, if a spouse relapses in terms of an addiction, alcoholism or drug use, I get his 401k, for example. That is also not enforceable. Don't put it in. In terms of the public policy, Peter mentioned, when there are marriages, when people are getting married and one person is not a U.S. citizen, and the expectation is that they'll be getting a green card, there is a separate federal affidavit that the sponsoring spouse needs to provide that indicates that, a certain level of support will be provided. So the premarital agreement does not override and cannot, conflict with that base minimum level of support that has to be provided pursuant to that affidavit. And generally, the violation of public policy, we'll talk about spousal support in more detail, but that's kind of where, we think about this issue of, okay, is the limitation or waiver or whatever we do on spousal support going to violate public policy? We'll talk in detail, but California has very strong public policies relating to spousal support, particularly in the realm of duration. So we always have to be mindful, is what we're doing, is it going to be consistent with the general public policy in California, which we know is very pro spousal support.
We did get a question, can there be an agreement to set up in case the child dies? And that's sort of crossing the line between child and spousal support. I presume, I don't know the answer to that question. That would probably be more of an estate planner. Do you have any input on that question?
That's my instinct as well. I think that's really more routinely covered in estate planning documents. What happens if, a parent dies or the child dies or something that effect.
Yeah, it's what I tell people is so common. They want somebody to do the dishes or sweep the floor or whatever household chores. So go to a psychologist and have them write up a personal agreement so you can do it. It's not enforceable in a court, but it's sort of a moral agreement and it takes it off us. And one of the reasons we don't want to put it in the agreement, you throw in too much like that, it might impair the totality of the agreement. It looks so silly that no judge would enforce it. Yes, there is a severability clause. It says if this clause is enforceable, the rest of the agreement is enforceable. But this is a serious legal document. It would be like writing on a deed, you know, please do the chores. I mean, it's silly. So we don't do it. So premarital agreements, two main types of agreements in my mind. Let's just say that California law and any other state sets out a default regime. There's no other agreement. This is what is going to happen. And you need a bevy of lawyers to tell you what that is. And it may be in the tax code, it may be in the family code, it may be in the probate code as we require. But you're changing this default regime by entering into a premarital agreement. There are two types of agreements, basic types. Of course, there are hybrids and all sorts of variations, but one is a confirmation agreement. Confirms what is separate and what is community. It might isolate an asset like a professional practice and says, my law practice is going to always be my separate property. You will never be able to have it valued in a divorce and determine goodwill. Or it may just confirm that this apartment building that I own before marriage, even though separate before marriage, will always stay separate even if I manage it. And that is fine. We don't do those for the most part. I have done them in my career, and I've done hundreds of these agreements, but I don't like to do them. And I'll get to why in a second. The other type of agreement wipes out the community property regime in California. Says there's no community property regime, changes the default to everything is separate except what we say is going to be community, which is usually section 7 of the agreement, and it lays out what will be community. Why don't I like confirmation agreements? It's because the law is complicated and people's actions over a lifetime are so unpredictable. If you say, for example, my apartment building is going to be my separate property no matter what, and you sell that apartment building, you get another apartment building, or you sell it, and you take the proceeds and put it in a house, things don't ever remain the same. It's chaos theory. So to take one or two assets, my professional practice is my separate property. Well, what if I merge with another law firm and build it up to another practice, or bring in a partner, or sell it, and start a new partnership, or become an employee? What about all that? So it's safer to start with a clean slate and then pick the things you're going to share. I would say in a confirmation agreement, you're giving it a duration of just a few years. And because it's not mentioned elsewhere in this agreement, that I think is a nasty little California statutory case law rule called the intent of the lender rule, which says that money that you borrow is community property if the lender relied on community property to make the loan. And the community property may be earnings, the community property may be efforts of the parties. It gets really messy. And people think of loans as being a debt. In this context, as a loan could be a margin loan. A loan could be a borrowing against real estate. A loan could be going to a third-party lender, a bank. Any kind of loan, as long as that lender relied on community property, all the proceeds could be community property. And that the proceeds might go into another piece of property that was separate property and get what we call in our lingo commingled. And then you can't determine what is community and separate. And you might say, well, that could never happen to me. Well, 30 years from now, is a whole different story. You don't know what's going to happen. And not to mention the law on the lender relying on community or separate property. There are cases that go different ways, and it's pretty unclear. So there's going to be a legal fight. And one of the points about a premarital agreement, it avoids all the disputes in litigation relating to what's community and what's separate, or it tries to avoid them.
And what I'll add is that, most people who sign premarital agreements put them in a drawer and don't ever look at them again unless they get divorced. So, to Peter's point, it's very rare that a person, like if there's a confirmation agreement, for example, it's very rare that at every step of the way, a person with that type of narrow agreement will be pulling out the prenup, reviewing it, calling their lawyer, as they should, and saying, how does this potential move I'm going to make impact, what happens under the prenup? What steps should I take? How should I plan? It just very rarely happens. It's the exception rather than the rule. So we operate with that assumption that nobody's going to be looking at this, that there are all types of ways that this could get mixed up with, efforts and monies and loans and all sorts of stuff over the course of, decades. And so that's why typically our preference is to have, the entire regime and all the rules governing it spelled out in one document. So the next topic which we've touched upon, is spousal support, and including spousal support provisions in premarital agreements. And this is truly, as the slide says, an educated guessing game. So there are two elements to spousal support under California law, under default California law, and that is duration and amount. So amount is obviously how much will be paid on a monthly basis, and duration is for how long will spousal support be paid. So again, under California law, without a premarital agreement, the duration of spousal support depends generally on the length of the marriage. So for parties that were married presumptively, generally for less than 10 years, as of the time of separation, spousal support, the duration of spousal support is half the length of the marriage, presumptively. It's not ironclad, but that's the general rule. Half the length of the marriage if you were married for less than 10 years, which is considered a short-term marriage. For a long-term marriage, which is considered presumptively to be any marriage over 10 years, spousal support is of indefinite duration. It doesn't automatically mean you're going to be paying spousal support for the rest of your life, although it may. But the point is, at the time of divorce, the court does not have the ability to set, when you're in a long-term marriage, the court does not have the ability to set an end date for the spousal support. The court, in other words, retains jurisdiction. So it's very significant for us to keep these policies in mind when we are drafting premarital agreements. In terms of amount under California law, that totally varies. It's a subject of a lot of litigation. There are numerous factors that the court considers in determining the amount, such as, the parties' respective, incomes, earning capacity, resources, marital standard of living, et cetera, et cetera. So we typically, notwithstanding all that, we typically do include spousal support provisions in most of our premarital agreements. So, as I mentioned earlier, we do not recommend outright waivers because they're just too risky. You don't know what's going to happen down the road, who's going to be working, who's not going to be working, who stayed home with the kids, circumstances that change. So we typically do not do a spousal support waiver, even if somebody says, okay, I'll make a payment, a large lump sum payment in lieu of support. I mean, it's possible, but honestly, the amount, in our view, the amount that, because generally wealthy people are getting premarital agreements, the amount that would need to be paid to have a chance of, being acceptable is so high that most people, don't want to do that. So we often, though, include limitations or caps on spousal support. So for duration, we typically will limit it to half the length of the marriage. So regardless of the length of the marriage, we will cap the spousal support to be paid at half the length of the marriage. In terms of amount, this is where this is the subject of much discussion and debate in our office, because we really, what you're doing with amount is you're looking to see what will a hypothetical judge believe to be unconscionable or conscionable at some hypothetical future point down the road, either short-term down the road, long-term down the road, based on circumstances that exist at that time. And nobody has a crystal ball. So it's key to, the factors we look at are not only what the couple is earning now, but what they are projected, what you can kind of reasonably guess that their earning capacities will be. Is one person planning to stay home or not? What is the couple's lifestyle going to be like? Those are some of the factors that we consider in selecting an amount, with the eye of, is this likely to be found? I mean, will this hopefully be viewed as not unconscionable at the time, of enforcement? And that's why it's important to be fair and reasonable. And the reason it's somewhat of a guessing game is because there's really no case law that guides us on this point. We get this question a lot, like, okay, well, just what's the amount? What's the minimum amount I have to provide? Let's just do that. That will make the agreement enforceable. That number, that guidance, it just simply doesn't exist. Around 2000, the statutes governing premarital agreements were amended to provide that, a spousal support provision, a court will not enforce it if it is found to be unconscionable at the time of enforcement. So that's that future time that we were talking about. So there is, because that amendment was, 20 years ago, it takes actually a long time for a body of case law to develop. And so we simply don't have that, on point guidance. So it's sort of a feel. Peter, do you have anything to add to that?
Yeah, the term unconscionable, we don't know if it means fair or shocking to the conscience as a normal contract would. There's a whole body of case law regarding normal contracts. It says shocking, what defines shocking to the conscience. But this is not a normal agreement. And other states have case law, and it's all over the map as to what is unconscionable. So because we don't know what a court would determine to be unconscionable, we guess at an amount. And the higher the amount of support you put in the cap, and a cap means any amount up to $7,000 a month, $10,000 a month, $20,000 a month, the higher the cap is, the more likely it would be that a court will enforce that agreement. So clients, their tendency is, I want the lowest cap possible. And they're saying, no, you want the highest cap possible. If you want this to be enforceable, make sure that you've got a high cap. You also want to be very careful about writing in percentages, like a percentage of my income or something like that. Because I had a fellow who agreed to pay a certain amount based on his income for the year. He sold a medical device that year in China, made $40 million, and he had to pay 17% of that to his wife. He was not a happy camper. I didn't write the agreement, just for your information, but I knew about it. So whenever I hear about percentages, it makes sense. But in this context, it doesn't. And if you're going to do a percentage, do a percentage with a cap. So this is a real unknown. We don't know what the courts will do with it, but every client wants it. I mean, every client since the year 2000 has wanted a limitation on spouse support.
And I'll add one more thing. The caps that we put in are, with the change in the tax law last year, alimony, spousal support, no longer deductible to the payor, no longer taxable to the payee. And so the amounts that we put in terms of the caps are tax-free dollars. So that's important to note. And then the other point is that, people often, people like Peter said, people say, I want the lowest possible cap, but The reality is if the cap is so low that it is not enforced, you're buying, you're just then going to be going under California law, which is like, okay, who knows? And in my experience, I used to practice in New York. California spousal support is high, relatively speaking, at least in compared with the numbers that, I was seeing in New York. It's a very, real significant obligation under California law. And then also there's going to be litigation about it, most likely. And spousal support litigation can be expensive because it's looking back as to income, which is not always just straightforward if somebody's not a W-2 wage earner. So it's looking back at income available for support and also what the lifestyle was. And to do a look back at a marital standard of living can be very costly and time consuming.
So the other powerful thing agreements do is regulate death. And we're divorce lawyers, we're family lawyers, so we're really looking at these agreements through that lens. So we love it when an estate planner works with us to draft these clauses. There's no estate planner involved, we'll do sort of the bare minimum. People can always provide more, but this is the minimum amount as opposed to a cap. This is the least that people will do. And our agreements start with a waiver of all intestate rights to take as a pre-terminated heir, any possible claim against the estate. And some of them stop there. There's no other clauses in the agreement. And that can be great because if somebody tears up a will or a trust or something, or it disappears, they would get nothing if the agreement is still around because it's a mutual waiver of all intestate rights. And, at times we consider not bringing them into the agreement, but really anybody that looks at this agreement is going to expect that marital waiver of all rights. It's called a marital waiver. It's really called a death waiver of any rights you would have at death. People are going to expect it in agreement. But there's another group of people that say, I don't know, I trust you, and I know you'll provide for me, but my lawyer says I should have some guarantee. If the couples can get life insurance, or the higher earner can get the life insurance, then life insurance, especially term, is a good solution. You can get a 20, 30-year term policy, or you can get a permanent policy for relatively cheap. You do need to determine whether it's going to continue beyond a divorce. I mean, if a marriage lasts 3-4 months, you don't want a lifetime policy. If a marriage lasts 5 years, you might not want a life insurance policy. So you got to make sure you might not want a life insurance policy to last longer than that. But as long as they're married and not separated, and you want to define separated, you can provide for them. Sometimes people provide based on a percentage of the estate. That can get very complicated because then you have to have everything valued, or there could be other problems with that. Some people want a lump sum payment, but that may not be available at the time the people die. And you want to make sure if there's a lump sum payment, is that after tax or pre-tax? And again, these are questions we would rather address with an estate planner who weighs in with us in drafting this agreement. Why provide for a spouse on death in a premarital agreement? Because somebody may not change their estate plan and may leave them with absolutely nothing. So they would want something in an agreement to provide for them. And so that's the basic reasons. Very important part of the agreement, not covered a lot in our agreements, but we will negotiate about this. Do you have anything else to say about this part of the agreement, Christina?
Just that, so whether, I mean, essentially whatever estate provisions you opt to include in a premarital agreement are sort of the minimum. you know, you're always free, spouses are always free to execute separate estate planning documents, which may provide, you know, more for one another. But to Peter's point, prenups cannot be just amended without the consent of both parties. So whatever's in that document is binding, whereas, you know, sometimes if people get mad at each other, you know, one of them changes, you know, meets with the lawyer and changes the whole estate plan and the other spouse doesn't know. So, you know, it's just sort of an extra layer of protection. But certainly, if we go, you know, if we include detailed estate planning provisions in our agreement, we will generally always loop in an estate planner as well to make sure it's an integrated document and, you know, that everybody's on the same page.
Somebody asked, is there any alternative to signing a prenup, such as asset protection plans? I see lawyers advertising some kind of scheme like that. I don't know if that will work. There's an article on a website by my father called Protecting Separate Property Without a Premarital Agreement, and it has some tips, and it's basically keeping all your assets separate. But it's nice in theory, but in practice, it really doesn't work. And I'm very leery of asset protection schemes, trusts, and so on. I've seen it done over the years. And basically, somebody's living their life trying to keep their separate property separate and avoid the California community property laws. Not a sensible plan. I would not recommend it. Do you have any comment on that, Chrissy?
I agree totally. I think, you know, I think it falls into the category of, you know, penny wise and pound foolish. And if people are really serious about wanting to take, you know, marriage is a very serious obligation in California. And if people are serious about wanting to protect their assets and provide for the, you know, regime, the prenup is the way to go. So the next topic we will discuss is the drafting, signing, and deadlines, which relates to the 60 days, minimum 60 days that you've heard us talk about from the beginning of the presentation. So as an initial matter, we'll go through in a moment really like a detailed week by week timeline, just so you can visualize exactly why these things take, you know, minimum of 60 days. But one very important change in the law to note that happened this year in 2020 is that now prenups cannot be signed less than 7 calendar days after the time that the final version was presented. And that's regardless of whether it includes people that are represented by lawyers. So to say it another way, both parties have a lawyer, final version is agreed upon, you know, the terms are all agreed upon, the document is circulated, nobody should sign that agreement until 7 calendar days, and ideally, you know, maybe plus 1 or 2 days, but the statute says 7 calendar days after that document was signed. It's a waiting period. It's a cooling off period, I guess you could call it. But this is a change in the law that has to be built in and factored in with, you know, the timeline that we're about to discuss. And the other important point is that no substantive changes to the agreement can be made within that 7-day waiting period. If a substantive change is made, that will, you know, you will need to restart the waiting period. So very important to remember, very important, I think, to tell the parties up front, because somehow, some way, even if we've got, you know, months, I don't know, it must be human nature. These things always somehow tend to get down to the wire. So it's just important for everybody to be aware of that in terms of wedding planning and finalizing the draft and really saying no more comments after this date. So the next aspect of it is there is no rule in California as to, you know, when before the wedding. There's no set number of days prior to the wedding that somebody can sign or not sign. But the 7-day waiting period is absolutely critical. Okay, so here is this timeline that I have spoken about throughout the presentation and hopefully shows why a minimum of 2 months is needed. So week 1, the attorney is hired, okay? Then, you know, the retention process and payment and meeting with the client to find out exactly what the goals are with the premarital agreement and why it's needed, and you know, just basically understand the terms of the engagement. Week 2, the attorney will prepare the first draft of the agreement. Week 3, the attorney will go over the first draft of the agreement with their client and make any necessary changes based on the discussion with the client, and then send the draft over to the fiance's attorney. Now, important point, this assumes that the fiance has already retained an attorney at this point. If the fiance has not retained an attorney, you can add probably 2 to 3 weeks to this to give that fiance, you know, the other person a chance to interview lawyers, hire them, get them retained, pay them, etc. Okay. Week 5, you get the comments back from the opposing attorney. Week 6 and 7, process of reviewing comments, discussing them with your client, revising the agreement per the, you know, agreed upon terms, and then at some point during that period, circulating the final version, at which time the 7-day waiting period starts. And then after that, we're already in week 8. And then assuming the 7-day waiting period has elapsed and assuming no further substantive changes have been made, the prenup can be signed. But critically, this assumes that this proceeds exactly as I've just outlined. It doesn't account for vacations. It doesn't account for 1,000 impediments that tend to come up during the process in our experience.
So we do have a question. How are potential tax law changes such as new alimony tax treatment incorporated into prenups? Really, nobody anticipated the current change or the change of the law about 2 years ago where they eliminated the tax deduction for alimony. And there are going to be a lot of agreements where people are questioning, you know, what the real amount should have been. Should it be tax affected? I imagine we'll see in the next 10 or 20 years cases on that. We write the agreement for the law now. We put in our retainer agreement that we can't anticipate changes in the law. Right now, we're writing the law as if there is no tax deduction for alimony and it's not taxable. But we don't put in our agreements what it would be if the law changes. But we do warn the clients in advance that we are writing a law for California law as it is today, and we can't predict what the law will be. So very important that somebody saves the agreement, and we also in our retainer agreements say it's the client's responsibility to save it. And we make 4 originals of the agreement. So the other side has 2 originals. We have 2 originals, one for the lawyer, one for the client. But it's their responsibility. And as I said, it's such a powerful agreement that it's incumbent on them to save it several places and keep it safe. And, you know, what happens, this is a great scene from the movie Intolerable Cruelty where Billy Bob Thornton tears up the agreement and he eats it before the wedding. You know, I could see litigation about whether that was a valid revocation. It looks valid, at least on film, but it's a great scene if you haven't seen the movie. But what if you tear it up or amend it or change it later on? Creates really interesting legal problems, and you need to see a lawyer before you tear it up, because does that mean prospectively or does that mean retroactively it's revoked? So everything that was separate property before that date now becomes community property. Very complicated, and people think it's simple just to change it. It isn't. Likewise, amendments to the premarital agreement are a problem too. You know, is consideration required? Not under the code, but one never knows. Also, anytime you change, is disclosure required? Is it a simple thing to amend a prenup? We don't like to amend them because it brings in a whole other document and other issues. So bottom line to this, a premarital agreement is a very powerful and final document. Not for everybody, but very useful for people with wealth who want to protect wealth, either for children who want to protect their parents' wealth, or parents who want to protect their children's wealth, or in situations where both people are wealthy, or in situations where a wealthy person is marrying an impecunious spouse. Although it's 10:30, I believe we could open it up for some questions. If anybody has questions, you could send a chat. Otherwise, do you want to have the last word, Christina?
I agree with Peter. A premarital agreement is a very powerful document, and they should be taken seriously, and they require time and thought and preparation. So that's what we'll conclude on.
And a perfect one other conclusion. A participant asked, "What do they cost?" Well, ours average a cost of $15,000 to $20,000. Don't drop off the Zoom at that, but that's what ours do. It can be a lot more. There are attorneys who will do it for, I've heard once polled a group and they said $500 for a prenup. I wouldn't like to see that prenup, but you probably can get them done for $5,000 to $7,000. And when we quote the $15,000, that's just for our side. The other side's going to need a lawyer, so between the two people, it could be $20,000 to $30,000. But what are you protecting? You're protecting a lifetime of assets and income. So they're very powerful. They are expensive. They're not for everybody, but for the right people. We're happy to talk to you about them. Email us, and please connect with us on LinkedIn. And you'll be getting an email from us, my partner, Chris Melcher. And if you would like us give us a Google like on our reviews, we really appreciate it. Thank you for attending, and look forward to chatting with you in the future. Feel free to call us or email us. Thank you very much.
Thanks, everyone.